One Sunday morning, a Mahindra Bolero moving at a speed of 132 kilometers per hour had crushed Raja's wife Pooja at a slight distance from him. Means Raja could only see a speeding vehicle from where he was standing and not the actual accident with his own eyes. She was getting treated in the ICU's critical care unit and died. And she died of heart attack. She died of heart attack after one day, that is on Monday evening, let's suppose. Now the question is, can Raja's evidence of what his injured wife said to him immediately after the accident on Sunday be considered valid? Answer is yes. By what rule? As per the provisions of the Res Gestae provided under section 6 of the Indian Evidence Act. Now what is Res Gestae? Okay. Before explaining what it is, let me give you a little brief about evidence under Indian Evidence Act 1872. We all know that evidence is required to decide who killed Pooja. Not only in this case, evidence is required to know who is right and who is wrong in any case. And that evidence can be oral or even documentary. According to the rule of best evidence under the section 60 of the law of evidence, the evidence must be given by a witness who says that he has complete full knowledge of the facts in the issue. Oral evidence must be direct. If some witness is giving an oral evidence, it has to be direct. The evidence not directly related to the fact, or which is not valid point in the case, is not admissible and is prevented under section 60 of the Indian Evidence Act. For example, if it refers to a fact which could be seen, it must be the evidence given by the witness who himself saw it with his own eyes. Example, if somebody goes as a witness and says, my grandpa when alive used to say Archana Neelambari is an expert in killing people like that. She also killed 3 or more people like that in our village, but there is no proof, there is no evidence to prove it, no documentary evidence or something like that. Such words are hearsay. As we all know, it is not valid. So what is hearsay evidence? It means evidence which is not direct, like our rumors or something heard from somebody. It is not admissible in the court. But remember, res gestae is an exception to the rule of hearsay evidence. That doesn't mean rumors are accepted, but in the above Pooja Raja's example which I created, what is hearsay evidence? The second hand evidence or the indirect evidence, that is something that is heard from somebody. What is it in that example, Pooja Raja's? The injured Pooja said something to her husband immediately after the accident. This line which I said in that example is hearsay. or second hand evidence in this case. Why it is hearsay? Because she is the only eyewitness who saw the person in the driver's seat, and she is not alive today to take an oath and give any evidence. So now, can they consider Raja's evidence even though it is not a direct evidence? Because Raja has not seen the actual accident and he has not seen who is driving the car also. So it is not a direct evidence as given in the section 60 of the Indian Evidence Act 1872. So can his evidence be considered? Yes. Why? Why is it considered? We know that section 5 to section 55 of the Indian Evidence Act deals with the relevancy of facts. What facts are relevant and what are irrelevant to the cases in the court. The rule said in section 6 of the Indian Evidence Act is known as the rule of Res Gestae or the doctrine of the Res Gestae. Though the term Res Gestae is not clearly expressed in the Indian Evidence Act 1872, it is not clearly given, but the term is analyzed in section 6 and it has attempted to illustrate in sections 7, 8, 9 and 14 of the Indian Evidence Act. Now, what is Res Gestae? According to the section 6 of the Indian Evidence Act, what is it? Section 6 says that the facts of the same state of affairs or the facts of the same transaction are relevant. They are relevant whether they occurred at the same time and place or at different times and different places. Even hearsay evidence is admissible under this section 6 of the Act. If they formed a part of the transaction, if they formed a part of the same transaction as by the definition of section 6. Here, Pooja died in the hospital because of heart attack on Monday. But what she said to Mr. Raja on the spot of the accident on Sunday is also relevant to the case. As per which section? Section 6. So now tell me, can Raja's evidence of what his injured wife said to him after the accident be considered? Yes. Why? Because it is a relevant fact. By which section? As per section 6 of the Indian Evidence Act, that is doctrine of Res Gestae. Hope it is clear.